Hello, my name is Ron Chichester. I'm making this presentation regarding copyright and artificial intelligence. What we're going to cover in this particular presentation is the copyrightability of content that is either partially, wholly, or to some extent modified or created using AI. This presentation is made in November 2025. And let's do the bottom line first, right? So the Copyright Office is the one that actually registers copyrights for the United States, and they are the ones that you really have to pay a lot of attention to for copyrightability. And they say that the current and past case law is sufficient to address the availability of copyright for AI-enabled or AI-generated content. Now that's a big deal, right? And so what they're saying is all the case law related to copyright for originality, the merger doctrine, for whether or not it's an original work, a derivative work, a collective work, or a compilation, all of the case law and such that already exists out there is fine for it. Is already there, still good law, right? Now, there were some other key findings and such that the Copyright Office basically, they wrote a big report and it had some key findings, all right? That human authorship remains an essential requirement. That is a biggie. And we'll talk about it in a little more depth later and such, but human authorship is absolutely essential. It has been since the beginning of copyright. It remains so today. Now, because of that, the fact that you're using an AI tool, just like you use a paintbrush or you're using a sound recording device or whatever, that does not affect the availability of copyright, right? So the AI can be used, enhanced, things like that. It's just like another tool, right? The same tool that the authors or musicians use or whatever. It's just a tool, right? Now, there is the kind of characteristic issue or unusual issue of purely AI generated material that is not copyrighted. So if the AI generates content without really any kind of human intervention, there's some basic, hey, go do something, that's not going to be copyrightable. Now, what this means, though, is because there has to be some human involved, there has to be some creativity by that human and that it shows up in the work. All this stuff has to be done on a case-by-case basis. How much was done by AI? What was done by AI? What was done by the human? Was the stuff that was done by a human have that spark of creativity? Things like that. And we'll discuss that in a little bit. Now, there is issues with human creation, human authorship, right? It's still absolutely essential. In fact, that has not changed, all right? It's straight out of the Constitution. Article 1, Section 8, Clause 8 allows for Congress to provide to authors for limited times to authors an exclusive right to their writings. Right, that's called the intellectual property clause. There's a corollary there. There's the other part of it's for patents as well, right? But it's straight out of the Constitution for now. The Supreme Court last held about who the author is. The author is the person that translates an idea into a fixed and tangible expression. Copyright, when you get a copyright, the copyright covers the expression of an idea, not the idea itself, but the expression of an idea that is done by an author, created by an author, and fixed in a tangible medium. That's the definition. Now, AI has been in the news lately and such, and there was a guy who went through and created a software program that cranked out conceivably copyrightable works, and went through and tried to get those works registered. Basically, applied for a copyright with the Copyright Office. Copyright looked at it, said, "Hey, I did it. No human intervention, no copyright." Thayer, the guy who did this, took it on appeal. He lost with the Copyright Office, took it to the district court, lost with the district court, took it to the Court of Appeals for the D.C. Circuit, and lost there in a unanimous vote. All right, so the courts are clear. You absolutely have to have a human in the loop. There is human authorship is essential to the copyrightability. Now, there's some other legal principles and such that are involved. The originality standard. There has to be some creative spark. As I mentioned before, the human has to do something that is kind of different, that has their own, basically that author's own expression of the idea, right? There's a low threshold. In the Feist case, it was really low, but there was sufficient, right? So there has to be a sufficient, what we call originality, in the work by the author, in order to get a copyright. Now, there's a few things that you should know about copyright. There's something called the idea expression dichotomy. Uh, Now, copyright protects the expression of an idea, but not the idea itself. Facts are not copyrightable. In fact, if there's only way to express one way to express an idea, that is not copyrightable either, right? It's only something there has to be enough ways to express an idea, and you pick a way that hasn't been done before. That's the originality aspect, and that's the stuff that's copyrightable. Uh, AI people ask me this, I don't know how many times, but they say, hey, look, we've spent all this time and effort to get these large language models to go through and generate all this content. Isn't all that money, isn't all that time, isn't all that hardware, isn't all that burned electrons and burned energy and stuff enough to get us copyrightability? And the answer is no. So, when AI is just a tool, that's where you can get some copyrightability. When the AI is used to assist the human in doing something, something creative in particular, then copyright's available. So, enhancing the color imagery, making me look younger on a video, removing unwanted objects from screens, music, where you're going through and you're tweaking the sharps to a flat or something like that to make the music a little different. That's where you're using AI to help you out, but you're still the author because that all that content for the most part and stuff, not all of it, but most of it was done with the human. So AI enhancements and stuff, the enhancements are not copyrightable, but the stuff that the human did to get the enhancements is copyrightable, right? Um, Now, another aspect, and people ask me this all the time and stuff, is, hey, can I get a copyright and a prompt? Well, conceivably, if you can get an idea and you express the idea in a prompt, then the prompt is copyrightable. However, the results from the prompt in the generative AI is not copyrightable. You have to have something more than a prompt. Now, let's take an example. I write a prompt, I cause the AI to generate a bunch of text, and then I take the text and I say, oh, this didn't come out right, or I want to tweak it, or I want to say it this way and stuff. And when I start tweaking and stuff, I can get a copyright for my tweaks. But the underlying text and stuff that was generated by the AI, even if it was my prompt, are not copyrightable, right? So, expressive inputs and stuff, that's the stuff for copyrightability, right? When the stuff that the author did is perceptible in the final work, the stuff that, and then a copyrighted stuff is possible, right? So this takes actually, like I've modified the original illustration from the AI. That's great. I change, you know, the work, my textual work from female centric to male centric or something like that. That's all doable. Photoshop, if you will, Photoshop, AI photoshopping, things like that. So long as the human element, the stuff that the human did and stuff comes through in the work, then you can have copyrightability. Another aspect, incidentally, of copyrightability is modifications and arrangements. So there's something in copyright law about selection arrangement. You can have three works from AI, and if you select them and arrange them into like a story where they're that arrangement and stuff, where this AI starts telling a story and stuff, the selection and arrangement of the AI is itself copyrightable, even though the underlying works themselves are not copyrightable, right? Same thing, editing AI outputs, iterative editing, where you're vibing with the AI to go through and get some work done, code. That's actually where I do a lot of my stuff. I use AI extensively when I'm writing software code. A lot of grunt work and stuff is just not done by humans anymore, and so a lot of code of mine is not copyrightable completely like mine back like it was back in the old days and stuff. And I don't care. I just want the code, right? So the thing you have to remember: the copyright extends to the human contribution, not the stuff that was generated by the AI. One last aspect before we get to the policy considerations is the international approach. Why I put this in here was because there's always a concern that some country somewhere tries to pull a Delaware and go to the lowest common denominator and say, hey, we will allow AI content to be copyrighted. And if you're a member of the Berne Convention, which the United States is, then there is a certain amount of recognition of this internet, of this copyright for an AI generated work. Fortunately, pretty much the rest of the planet, for at least the major countries in the planet, are adopting the same kind of notion that the United States is, that the copyright requires human authorship, that there has to be some aspect in the human. The human has to be able to do something, and that something has to show up in the final work in order for copyrightability. So the top three ones, of course, South Korea, Japan, Asia, China. Those are the major countries in Asia, and of course the European Union and the United Kingdom. They're all on board, and of course the United States and North America, and presumably Mexico and Canada. That's North America. That's pretty much, except for Africa and South America, that's pretty much the whole planet. But these are the major players in the copyright world. So they're all on board. They're all in line, and that's a great thing. Now, there are a few things about policy considerations, and that may have an effect on copyright in the future. I'm beginning to doubt it now, because the Copyright Office kind of, come through and said, and the way the Copyright Office has been handling it seems to work pretty well, and so I don't foresee that major changes by the Copyright Office anytime soon. But just keep in mind there are certain things, there are certain policy arguments and stuff that we want. Arguments for copyright and for AI enhanced copyright are it generates more works. And I certainly can crank out more works with AI than I could before. So that helps. It empowers creators who have disabilities. And a friend of mine's got ALS and he's dealing with that. And AI is just a godsend for that man. So he's, there's a really good case there for arguments to allow even AI generated content that have human elements in it and such to be copyrightable. We want to stay competitive with other countries on the planet, so we want to harmonize our laws with theirs, and that puts us more on a level playing field and doesn't give those other countries a leg up on the United States. We also, from the copyright standpoint, they want clarity. They want this thing settled. They don't want any more Thayer cases. They don't want the Registrar of Copyrights getting sued for AI companies and things like that. So that's all there and good. There are some arguments, just so you know, against AI enhanced works being copyrighted, and that is that the some people want and think it's better to have all of the content generated by a human. From a job standpoint, I get that, but also there's a lot. The whole idea is there's a lot more work, and there is a lot more works that are coming out. And so even if the humans aren't getting the lion's share of it, they're at least getting something. And from the public standpoint, there's a lot more work being generated, and that's an important thing. No matter what, however, there is the constitutional limit. There has to be a human author. That's not changing short of a constitutional amendment, and I cannot imagine the country getting even enough attention to the intellectual property clause of the U.S. Constitution to go through and make an amendment of it. I just don't think that's ever going to happen. So the existing case law is pretty much good, and so we don't have to probably shouldn't have to worry about the content flooding. That's an argument. By the way, that's another thing. If you're arguing against copyrightability by AI, the content flooding risk, where the humans are just, there's so much noise around, the humans can't get a word in edgewise and stuff, and then authors can't get their works published and stuff. So keeping with existing law and such is probably going to prevent that. So to wrap things up, the Copyright Office, the big 900-pound gorilla in the room, is saying the existing case law is sufficient, no legislative changes needed. AI is a tool. When it's being used as a tool, there is copyright available. If it is used as a substitute for a human, no copyright available. And that is one more thing. Because you can't get it for wholly generated works by AI, but you can get it for humans when there's a hybrid work, meaning it's partially generated by AI and the rest of it was generated by a human. That's a case by case basis, and you have to go through and nitpick. Now, when you're making the registration applications for what's called original works and such, you're going to have to address how much of it was done by AI, and you have to tell the Copyright Office, hey, this part was generated by AI, the rest of it was generated by a human. The Copyright Office has to know that. Prompts alone are not enough. You've got to have more. There has to be something human generated that is perceptible in the output, either by the selection and arrangement, or modifications, or enhancements and stuff that were done by the humans. And the Copyright Office has said, yeah, the scope of copyright, and in most documents that have something in AI with them, the scope of the copyright is less for the human author. Too bad. That's just too bad. Okay, no additional protections for authors. All right. So if you have questions, there is the Computer and Technology section of the State Bar of Texas. That's where this presentation was made. And we have a bunch of people in that section such that are capable of giving you a lot more information on this area and other areas, and how to use computers and such for the practice of law, as well as for clients and such. So if you have any questions, sbot.org. That's sbot.org, statebaroftexas.org, SBOT. And my name is Ron Chichester. Thank you very much for listening.